Maybe you were only trying to protect yourself. Maybe the other person attacked you first, but when the police showed up, they didn't care and they arrested you anyway. Now you're facing serious charges and you're wondering, isn't this self-defense? Shouldn't I be protected under the law? Unfortunately, it is not that simple. California allows self-defense, but only if your case meets every legal requirement. Miss even one and your defense could fall apart. That's exactly what we're going to cover today. I'm breaking down the 5 legal requirements for self-defense. My name is Veronica. I'm a domestic violence defense attorney, helping people throughout the entire state of California put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a DIY course on how to represent yourself at your restraining order hearing and win. So if in addition to dealing with a criminal case, you're also fighting against a restraining order, make sure to get your free first Defeat the DVRO class via the link down below. Okay, let's get started. In California, self-defense means that you used no more force than immediately necessary to protect yourself from being hurt. But what actually counts as self-defense? The answer may surprise you. So let's go through our 5-part checklist with some examples to break this down. And make sure to stay until the end because factor number 5 is where a lot of people who think that they have a self-defense claim end up failing. Number 1, who started it? Your self-defense claim depends on who initiated the physical contact. If you started the fight, it weakens, although it doesn't necessarily totally destroy your right to claim self-defense. But if you are merely responding to someone else's aggression, your case is going to be much stronger. Let's get into an example. Meet Roger.
I was arguing with my girlfriend, Patty. Suddenly, she slapped me across the face. I was stunned for a moment, but before I could react, she raised her arm for another slap. Instinctively, I shoved her away to stop her from hitting me again. She fell, and now I've been charged with domestic violence.
Okay, so let's break it down. Since Patty was the one who initiated the physical aggression, and Roger only shoved her away to stop her, this one is a clear case of classic self-defense. So, thinking of your own case, if the other person started the physical altercation and you were just responding to their aggression, give yourself a point. If you initiated the confrontation, even if you later tried to stop or back out, then you don't get a point for this one. It doesn't mean that your defense is necessarily dead in the water, but it is going to take a much more thorough analysis to see how it might apply in your case. Number 2, was the danger immediate? If the attacker was clearly about to strike, then use of force can be justified. But you can't use force on someone just because you were afraid that they were going to hurt you later. So let's get into an example of this.
I was in our living room, and tensions had been escalating for hours. Suddenly, my girlfriend, who had been verbally aggressive all evening, grabbed a kitchen knife and came toward me. She didn't raise the knife, but I was concerned that she might try to attack me. I grabbed the knife from her and shoved her away. She fell into the coffee table and ended up with some bruises. She called the police, and I got arrested.
All right, so let's break this one down. Alex's girlfriend is holding a knife, which is scary, but self-defense requires an immediate attack or threat of attack. If she wasn't lunging, swinging, or raising the knife to strike, his reaction may not qualify as self-defense. So, turning to your own case, if you were faced with an attacker who was clearly about to cause harm, then give yourself a point, even if no injury occurred. Now, if the threat wasn't immediate or you're not sure, then do not give yourself a point on this one. Number 3, whether an average reasonable person in your position would have done the same thing that you did, basically, to stop the other person. So let's meet Maria.
My husband and I argued a lot. He'd never physically hurt me, but I thought he might. One night, I found a note on the kitchen table. It said, "I'm done talking. We settle this." My stomach dropped. I read it over and over, terrified. I froze and then heard footsteps. He walked into the room toward me. His fists were clenched, and he looked furious. My heart was racing, and in that moment, I felt that he might kill me. I shoved him as hard as I could.
All right, so let's break this down. Now, Maria's fear was real, but she jumped to a conclusion here that I don't know that most reasonable people necessarily would. Her husband said that he's done talking, which could be taken as a physical threat. And he did look angry and he was walking toward her, but he wasn't actively trying to attack her. He'd never physically harmed her before. This would be a hard sell for self-defense. Now, looking at your own case, and this is going to be a little bit hard because everyone believes that they are reasonable. Think about whether a reasonable person in the same situation would have thought that force was immediately necessary to stop the other person from attacking them. Now, if there's any doubt, or if the average person might have waited or handled the situation differently, no point for this one. Number 4, did you actually believe that you needed to act in self-defense? It's not enough that a reasonable person would have feared harm. You must have genuinely felt threatened in the moment. So let's get into an example of how this could play out. Meet John.
During an argument, my girlfriend told me that she was going to kill me and came toward me. She said stuff like that before, and I knew she was just being dramatic and she wouldn't really hurt me. I shoved her to the ground. She slipped and hit her head. Later, I texted a friend saying she's been cheating on me for weeks, and she finally got what's coming to her. The cops arrested me, but it was a clear case of self-defense. It's going to get dropped in no time. She admitted to them that she threatened to kill me.
So breaking this one down, even though an outsider might have believed that John was in danger, he himself was not scared. That text message is pretty good proof that his real motive was not self-defense. If this gets into the hands of the prosecution, John's story is going to be a very hard sell for self-defense. John's demeanor and what he told the police when they first came out, if he talked to them, are going to be key for a self-defense claim here. All right, so in assessing your own case, if you truly felt like you were in immediate danger and there's no evidence to the contrary, then give yourself a point here. But if you didn't actually feel scared, or if you claimed that you didn't feel scared, or if you were kind of stoic and when the police came out, you didn't act very scared, then don't give yourself a point for this one. This one might be more of a question mark for you. Even if you have 4 points so far, there's still one more way that your case could fall apart, and this is the one where a lot of people who think that they have a strong self-defense claim end up failing. Number 5, did you use excessive force? Self-defense is only valid if your reaction was proportional to the threat. Let's meet Linda.
During a drunken rage, my husband Harry hit me repeatedly. This wasn't the first time. I went to our bedroom and got our gun from the safe. I wasn't planning to shoot him. But when I came out of the room, he came at me to hit me again, and I shot in his direction once before he got the chance. I ended up shooting him in the leg.
All right, so let's break it down. Harry was violent, and Linda had a right to defend herself. But the question is, was shooting him necessary to stop him, or did she overdo it? Especially when there's a gun involved like this, the prosecution could very easily argue that she overreacted. But we have to look at what other options did she have. Depending on her size compared to Harry, depending on what options she had, then using lesser force may not have actually been a viable option. And we know that he'd already hurt her before. Since she only shot him once in the leg and then stopped, Linda has a good shot here, no pun intended. But if she had kept attacking, if she had shot him multiple times, then the court could see her response as an overreaction or as excessive. So turning to our checklist in your own case, if you used only the amount of force necessary to stop the threat, and you think a reasonable person in your situation would agree, then give yourself a point. But if you maybe went overboard, if the other person was hurt more significantly maybe than you intended, or if you used more force than needed, or you used a weapon and the other person didn't, then don't give yourself a point in this section. It does not mean that your defense will fail, but it means that it's going to require a really intensive analysis of all of the facts in your situation and portraying them in the best possible light. You've gone through all 5 factors, so let's see where you stand. If you are at 5 out of 5, you have a strong self-defense case, but that does not mean that the court will see it that way. You still need a lawyer to make sure that your case does not fall apart and that it is presented perfectly to the other side. If you got a 3 or 4, your claim is shaky. You need to talk to a lawyer and see, is this a case where self-defense is the best strategy, or is there another strategy that would work better? If you got a 0 to 2, maybe you're a little bit too hard on yourself, but your claim might also be weak. And you do need to rethink your defense strategy and see what else applies, or you are at serious risk of conviction. Even a strong self-defense claim can fall apart without the right legal strategy. I hope you found this video helpful. And look, if you have been arrested, time is working against you. Every hour you wait helps the prosecution build their case if there's nobody on your side building yours. So if you need help with your case, if your case is in California, feel free to book a consultation. You can find my number down below. You can also book a consultation directly via the link there. And if you did find it helpful, please don't forget to like, subscribe, ring the bell. And if you have a question or a comment, leave it in the comments.